Hello, everyone, and welcome to a new session with Rights and Responsibilities Awareness Initiative. Today, we are lucky to have Kristin A, partner from Cohen Highley LLB, that well-known law firm in Ontario, to talk to us about a very important topic for so many of us: renting an apartment. What is the legal perspective, the legal procedures, how we can protect ourselves, how we can avoid being a victim for any potential fraud. Thank you very much, Kristin, for being with us today.
Well, thank you very much, Haytham, for having me. It's great to be here. I'm excited to chat about this very important topic, as you say. Am I good to go?
Oh, yes, please.
Yes. Okay. Fantastic. Okay. So as Haytham indicated, I am a lawyer at Cohen Highley, and I do practice primarily for landlords and property managers. So it's really exciting to actually be addressing an audience that maybe is more tenant focused. Hopefully I'll be able to impart some knowledge that I've gained over the last 15 years or so in working in this area. This is the area that I practice every day. And so I hope that I can share some important information with you and give you some things to think about. So as the title of this slide says, renting an apartment, a legal perspective. And just a reminder that this is my legal perspective. If you talk to any lawyers or paralegals, they all have different perspectives depending on their backgrounds and experience level and what they've seen and what they've done. So this is my perspective, but I am going to try to focus on the big picture initially, just to make sure that you're all aware of the laws that apply. Just make sure I can advance this. So here's the outline. So like I said, the laws that apply, what is the applicable legislation that we need to think about and be familiar with, or at least know where to find it to get some answers. We'll talk about the rental application process that a lot of property managers and landlords use on a regular basis. Then we'll talk about the standard form of lease, and I'll review it briefly with you so that you're familiar with what that document looks like, the kinds of information that it will have in it. And then finally, I'll talk a little bit about the Landlord and Tenant Board and the various pieces of information that are available on the board's website, as well as some other resources that you might find helpful if you have questions going forward about renting an apartment and specifically a residential lease. So to start then, the big piece of law, the legislation that applies to residential tenancies is called the Residential Tenancies Act. And this act is meant to provide protection for residential tenants from unlawful rent increases and unlawful evictions. So it really is, it's what we call consumer protection legislation. And it recognizes that there is often an imbalance in power between someone who's looking to rent a residential unit and the landlord or the owner of that space who's looking to rent it. So we have this piece of consumer protection legislation in place to essentially balance the rights of the parties, provide protection for tenants, and then also provide a framework for resolving any sorts of disputes that might arise out of a lease agreement. The Act also has a number of provisions that apply to the very outset of a tenancy. So what kinds of things a landlord can require from a tenant. So when we talk about last month's rent deposit, that's something that the Act actually speaks to. And has a section specifically about that. It also talks about what sorts of background checks and information a landlord can require. What kinds of rules can a landlord have? And it's important to keep in mind that the parties cannot enter into an agreement that is inconsistent or inconsistent with the legislation. So keep in mind that this Residential Tenancies Act applies despite any agreement, waiver, or law to the contrary. So if it's not consistent with the RTA, then it's probably not an enforceable term in a lease. Now, the one exception is the Human Rights Code. And that's because the Human Rights Code is really, it's almost quasi-constitutional legislation in Ontario, meaning that it's very close to the law of the land, just sort of below the charter. So if something is required under the code that's maybe inconsistent with the Residential Tenancies Act, the code is going to apply. It's going to have more force than the Residential Tenancies Act. And then when we're talking about, well, what does the Act actually apply to? Well, in most cases, it's going to apply to a rental unit that you might be looking to rent. So rental units are living accommodation used or intended for use as rented residential premises. Probably the two most common are going to be the apartments and rented condominiums. So units that we see in high-rise buildings or in townhouse complexes. And then rented houses is probably the next most common. So if you're looking to rent a single family dwelling, a house in a subdivision, that's also going to be considered a rental unit, and the same laws and regulations apply to it. And then a little less common is going to be mobile homes or land lease homes and mobile home parks. But the Act applies to those with a few differences, but again, the Act applies to that. And then rooms in boarding houses, rooming houses, lodging houses, or care homes. So care homes are more like your retirement homes where care services are provided. And then rooms in boarding houses are exactly what that sounds like, where you're just renting a room in a building or in a house where you're maybe sharing some amenities with other tenants, like a shared kitchen or bathrooms, things of that nature. And important to keep in mind as well that we talked about the Act being intended to protect tenants from unlawful evictions. So tenants who enter into residential leases have what we call security of tenure, which means their tenancy can only be terminated in accordance with the Act, with the Residential Tenancies Act. And so what you will find when you're looking for an apartment is that most tenancies will begin as a fixed term lease. So I've given some examples here. So maybe it's a January 1st start and it would run until December 31st, 2023. Or you could have a lease start at April 1st and it would go to March. So that initial fixed term is usually 1 year. That's pretty common in the industry and across most landlords and property management companies. And then after the 1 year fixed term, the lease actually automatically renews on a month-to-month basis. And so unless the parties agree to another fixed term, so maybe the parties have talked about wanting to enter into another lease agreement on the heels of this last one, and enter into another 1 year fixed term. So you could do that, but both parties would have to agree to that. Or you might have the parties agree to terminate the tenancy, in which case the landlord could re-rent the unit to someone else and the tenant would then move on and look for a new place. Perhaps they already found a new place and so they were waiting for the end of the lease and then they were moving on to a place that's maybe more suitable for their needs, or maybe a job change needed a relocation. Whatever the reason, it's up to the tenant if they want to agree to terminate the lease. And then the parties, of course, would agree to that. But because a tenant has security of tenure, a lease can only be terminated in accordance with the Act. So like I said, a tenant may terminate on notice. So they don't have to give a reason, and it can be at the end of the fixed term, or once the fixed term has come to an end and the lease has automatically renewed on a month-to-month basis, then the tenant can just give 60 days notice to terminate their lease. So those are all of the rights that a tenant has in ending a lease agreement with a landlord. Now, a landlord doesn't have the same rights. Again, because we have that security of tenure, we recognize it's important that people be stable in their housing. And so a landlord has to have a reason to give a notice. So, and we refer to those reasons as either fault grounds or no fault grounds. And so I've given some examples here of what fault grounds are, and that's if a tenant doesn't pay their rent, then the landlord is going to probably want to terminate the tenancy and get an order for the rent to be paid and then get the unit back so that the rent doesn't continue to build the arrears. If there's conduct issues, so if a tenant is not following the rules and regulations of the landlord or is interfering with other tenants' reasonable enjoyment, then the landlord might want to seek termination of the tenancy. When we talk about no fault grounds, those are grounds that through no fault of the tenant, the landlord wants to recover possession of the rental unit and wants to end the tenancy. In those cases, the landlord would have to give a notice, and there are some protections built into the Act with respect to how much notice has to be given. And there's also some provisions for compensation to be paid. So if a landlord is looking to terminate a lease, in some instances, they have to actually pay 1 month's rent or 2 months' rent to the tenant. So, and that arises with the no fault grounds of termination. So those are sort of the big concepts, the balancing of the Residential Tenancies Act, termination, starting the lease, and then how that lease actually terminates. So those are our big concepts to keep in mind. And then we get into rent, which is another big piece of renting an apartment. So if you are a brand new tenant to a rental unit, the landlord can set the rent for that rental unit at whatever amount that they want to charge. There's no limit to that rent. And I would say it's really just market forces that's going to limit how much the landlord is going to want to charge for that rental unit. So considering the size of the unit, the amenities that are included, all of those, location, of course, as with any real estate, location matters. And so all of those things will factor into what the landlord will look to be charging for rent initially. And then the landlord, after the lease has been entered into, and the tenant moves in, the landlord can only increase the rent once every 12 months. So tenants can expect to get a rent increase notice 90 days before the rent is going to go up, and it's only once every 12 months. So once a year. And then most increases in Ontario are limited to the rent increase guidelines. So each fall, the province sets what percentage residential rents can be increased by. And they let all the landlords know, they let everyone in the province know. And then landlords will generate their notices of rent increase in accordance with that guideline. Most landlords are going to look to increase the rent by the full guideline amount, which is capped in any year at 2.5%. So rent will not go above 2.5% unless there's an exception that applies. So there are some exceptions for new rental units. So if it's a brand new house or brand new rental unit, it might be exempt from rent control, in which case the landlord is legally allowed to increase the rent beyond 2.5%. So that's something to keep in mind if you are looking to rent a new place. So a building that was just constructed or a brand new house that was just constructed, it may very well be exempt from rent control. And then there's no limit to, new units, but also a landlord can also apply to increase the rent above the guideline if they're doing some work on the unit. So if it's an older unit and maybe it's in a building that needs a brand new windows or a brand new roof, if the landlord spends money on improving a rental unit, then they can go through a process where they can ask the Landlord and Tenant Board to allow them to increase the rent beyond 2.5%. But in most cases, you're going to be looking at rent increases that are limited to the guideline, except for those exceptions. So my message here is just be mindful if you are renting a new rental unit that probably the rent control does not apply to that unit. Now, leaving the Residential Tenancies Act now, and we'll move into the rental application. So most landlords and property managers do use a standard rental application form. So if you are, if you're, in London, in Toronto, and you're sort of looking at different units at various properties, you will likely find that the rental application looks very similar. The rental application is an offer to lease. So you would be completing a rental application and offering to rent the unit that is available at the landlord's property. And in order to do that, you are asked to provide a lot of personal information, right? You're going to have to provide your legal names, identification, whether it's government identification or otherwise, who's going to live in the rental unit. You're going to be asked to say who your occupants will be. Who are the proposed tenants? Usually proposed tenants are going to be any adult who's going to live in the unit, so anyone over 18. And then proposed occupants you would identify. So if anyone's going to be living in the unit that's not going to be a leaseholder or is not going to be a tenant on the lease. You will be expected to be able to provide the amount and source of income. So it can be employment income or otherwise. So if someone is receiving social assistance, so Ontario Works or disability, or has just pension income, or is retired and has investment income, whatever the source of income, that's going to be expected to be provided to the landlord, because the landlord wants to make sure that if they accept your offer to lease, you're going to be able to pay the rent on a monthly basis. And you want to make sure that you're going to be able to pay the rent too. So you provide that information to the landlord. Typically, you would need to be providing banking information to the landlord. Often this is done more as a financial reference. And then if you're going to have parking or you have a vehicle that you would need parking for, you'll be asked to provide vehicle information as well. And then references. And references, like I said, could be a financial reference, like a bank, but also personal references. And then if you've lived somewhere else before you're applying for this rental unit, you may be asked to provide your former landlord's name. Or if you owned your home and then you sold it, you may be asked to provide your former address information. And all of that information goes into the rental application so that the landlord can do some further checks on their end of things to confirm that you would be an ideal tenant. So one of the other things that the rental application will require is your consent to allow the landlord to perform those kinds of checks. So credit check is probably the most common check that a landlord will do on their own. And then also contacting references. Much like if you're applying for a job and you provide references, the same thing is going to happen with a landlord. They're going to want to talk to a former landlord or a reference that you've given who's going to say that you're going to be able to pay your rent. And the landlord will ask you for your consent to contact those people. You want to make sure that all of the information that you provide in a rental application is accurate. You do not want to make false representations in a rental application because it could form grounds for the landlord to ultimately terminate your tenancy. So if the offer to lease is accepted on misrepresentations, then that could really erode the underlying contract between the parties. So keep that in mind, make sure the information that you're providing is accurate. You'll typically be required to provide a contract deposit with the application. So this is usually it's the last month's rent, it's the same amount. as the last month's rent, and it's consideration for your offer to lease. So if it provides the consideration for your offer to lease, and then if the landlord accepts your rental application, then it changes from a contract deposit into your last month's rent deposit. And it's basically held as security until the very end of your lease. And in that last month of the tenancy, the landlord's going to apply that to your rent. So you're going to pay it up front, and then you're going to see the benefit of it at the very end of the lease. Now, under the Residential Tenancies Act, the landlord has to pay interest on the last month's rent deposit annually. And like I said, it can only be applied to the last month of the tenancy. And the amount is limited to what the rent is for the apartment. So you can't be asked to pay more money than just the monthly rent. So that's the limit to it. Most rental applications will require that you have insurance, or that you acknowledge that you're going to have insurance. Many landlords will require you to have contents insurance, so insurance to protect your personal belongings, but also liability insurance. And most landlords will require that you give proof of your insurance before they give you the keys to the rental unit. It's a very important document that you'll want to be able to provide your landlord with proof of. And then utilities, they're often not included in the rent. Some rental units do offer all-inclusive rent, in which case those utilities would be included. But I'll say that it's more common for them not to be included, in which case you would have to contract with a sub-metering company or a utility provider like London Hydro separately, outside of your agreement with your landlord. Internet and cable are rarely included with rental units as well. So you would be looking at contracting with a service like Bell or Rogers or another cable or internet provider. The rental application, when you're completing that, it will confirm what utilities are and are not included. So that information should be available to you at the time you are making your offer to lease. So you want to make sure that you're paying attention to the things that are included and aren't included, so that you don't have any surprises. Parking and storage lockers are also something that is typically available, but at a separate charge. And so once you agree to have parking or have a locker, then the amount that's associated with those things becomes part of the rent. And so if parking is $100 and your rent is $1,000, then your lawful rent is going to be $1,100. Air conditioning and laundry facilities, there may be separate charges for water and electricity use if you have in-suite laundry. Otherwise, many high-rise buildings will have coin-operated laundry, and so it's available at the building, but it's something that you have to pay per use to use. And then with respect to air conditioning units, if it's one of those ones that goes in a window or into an air conditioning sleeve, and the landlord pays for electricity to the unit, so if it's an all-inclusive rent amount, then you might find that there's a separate charge for air conditioning. And typically the separate charge will just be for the months where you would use air conditioning. So maybe from May until September, you would have a seasonal charge that would be added in addition to the rent. So those are all things that you would want to pay particular attention to when you're completing that rental application or your offer to lease, especially so that you know what is included, what isn't included, and really what that lawful rent is going to be, so that you're well informed. And then be prepared, of course, to pay that contract deposit, which ultimately, if your rental application is accepted, is going to convert into a last month's rent deposit and be held by the landlord as security. So now moving on to the standard form of lease. So we'll assume that you've submitted a rental application or an offer to lease, the landlord has accepted it, and now you are signing the lease agreement itself, the tenancy agreement. And since 2018, so relatively new. 5 years ago is not so long ago. The government of Ontario prescribed a standard form of lease, and this lease is long. It's 14 pages long, and that's the government's portion is 14 pages long. The first 7 pages are the lease itself, all of the terms that you will have agreed to with the landlord when you did your rental application. And then the last 7 pages are an appendix with information about each section. So it's very user-friendly. There's a lot of information on it. Like I said, it's long, it's 14 pages. And what you will find is that many landlords have attached additional terms and conditions to the standard form of lease. And so it's even longer when you have those additional terms and conditions. And many of those are about 10 pages. So it's a long document, but it's an important document. And it's one that you want to make sure that you're paying close attention to each of the sections and asking questions if you aren't sure. The standard form of lease is going to be binding on both parties, so landlord and tenant. And if it isn't written in the lease, then it's not going to be part of the agreement. And most landlords will have a provision in their additional terms that says exactly that. So if you talk about something with the landlord, maybe the landlord has said that they're going to replace the carpet, or they're going to do some other repair on the unit. Maybe they're going to paint it before you move in. You might want to make sure that that's included in the lease, or that you have written documentation about that. Because ultimately, if it's not in the lease, it's not going to be enforceable and binding on the parties. Now I've included here on the PowerPoint, and I'll make sure that this is available if that's an option, is there's a guide to the standard lease. So in addition to the appendix to the lease, there's also a guide on the Ontario government's website where you can read about the standard form of lease and get even more information. And it's available in about 20 additional languages besides English and French. So that's a great resource just to be familiar with the document and understand the different parts of it. And you are entitled to a copy of the signed agreement within 21 days after it's signed by both parties. So just before we go on to that, I'm going to attempt here to sort of, let me see if I can shrink that down just a tad. I don't think you need it so big. But this is the standard form of lease. So this is the first page of it. This is the document, what it looks like. Some landlords have you complete it electronically, so online. Others have a print copy, but it is a fillable form and it's in PDF format. And I'm not going to go through each of the sections, but I just sort of wanted to scroll through so you could see what it looks like and just sort of be familiar with this document. So the rental unit, of course, we talked about naming the parties. So the tenants' names would go here. The address, how our document's going to be served on each other. Then we've got the term of the tenancy agreement. So this is where you see that fixed length of time. So typically the initial lease is going to have a 1-year fixed term. So this is where you're going to see that listed. And then another important part is, of course, the rent that we talked about. So here you would have when is rent to be paid. Most landlords will require rent to be paid on the first of the month. That's just sort of standard in the industry. It would be paid on a monthly basis. And then here's where you get into the base rent for the rental unit. And then you'll remember that I mentioned parking or storage lockers can be additional charges. So then this is where those amounts would be written in. And then down here is where you're going to have your total rent. So that's going to be the lawful rent that the landlord's going to charge you each month for that rental unit. And then services and facilities, another one that we talked about. You've got, so gas, who's responsible for that? Is it included or not included? Storage space, laundry, Guest parking, are there spaces for guests to park? And then air conditioning here as well. And sometimes you'll see air conditioning, it's not included in the rent, but then you might have details down here. Your landlord might have specified what that seasonal charge might be, and then for additional electricity. So that's where you would see that. Rent discounts if they're offered. We talked about the rent deposit. Typically, you'll see this box checked off where it says the tenant will pay a rent deposit. And again, that's usually going to be that contract deposit that you paid at the outset of the lease. Key deposits, if any of those are charged, they'll be there. Smoking is really important to be familiar with those rules. Many landlords have no smoking properties or are in the process of converting to smoke-free buildings. And so you want to make sure you're aware of the rules around smoking, especially if you are a smoker. Tenant insurance, we talked about that as well. And then generally some terms about assignment and subletting, and other things that would apply to the relationship between landlord and tenant. And then we have, this is the part, additional terms. So you remember I said the lease itself is 14 pages long, but then many landlords and property managers have additional terms that they've added to the lease. This is where you'll see that. So this box here will be checked off, and it will say that it includes an attachment with additional terms that the landlord and tenant agreed to. So you want to make sure you're reviewing all of those additional terms as well. And then, of course, everybody signs it because it's a legally binding document. And then when you get to page 8, this is where you start to get into that general information about the lease. And you have this as a resource, but then you also have the guide to the lease that I mentioned previously. I'm just going to move that over to the side and we'll get back into our PowerPoint here. So hopefully just seeing it is helpful to some of you. So then we move to the Landlord and Tenant Board. So you'll remember from the outset that I mentioned that the Landlord and Tenant Board is sort of set up to help parties resolve disputes. Nobody really wants to end up at the Landlord and Tenant Board. It's not necessarily a happy place, but it is there if landlords and tenants can't agree on something. So if a tenant isn't paying rent or is late with rent payments, the landlord will start the process. Typically, it will start with a notice to terminate for non-payment of rent. So this is a Form N4, and it gives a tenant time to pay the rent. And if they don't pay the rent within that time, frame, then the landlord could apply to the board to have a hearing and get an order for the rent. So that's a common one where a landlord would need to go to the Landlord and Tenant Board. And a common tenant application, why a tenant might want to go to the board, is because there's maintenance issues. The landlord's not paying attention to a repair that needs to be done. Or there's generally a sense that the landlord just is maybe neglecting the property. And so a tenant would file a maintenance application and they would say, look, I've tried to speak to my landlord. I've tried to get this work done. It's not being done. And I'd like the board to require the landlord to do the work. So that's what the Landlord and Tenant Board, those are the kinds of things that the board is going to help the parties with if they can't resolve an issue themselves. We have now in Ontario an online system for the Landlord and Tenant Board right from the very beginning. So right from filing an application, all of that is done online now. And I've included a link to the Tribunals Ontario portal and also a link to Navigate Tribunals Ontario. So these are two excellent, well, the Navigate Tribunals Ontario is an excellent resource to sort of help you figure out what form you need to be filing or what application you need to be filing. It basically walks you through the process. You answer a number of questions, and at the end, it sort of tells you what you might want to consider. Of course, the preference is that parties work out their differences together, but we know that that isn't always possible. People don't always see eye to eye, and you need to have a third party involved in that process. So if you go to a hearing, it's going to be an adjudicator. If you are able to kind of have some conversations with maybe a third party, a neutral party, then there is mediation available through the portal or at the Landlord and Tenant Board as well. So that's something that is available. Those mediators are also known as dispute resolution officers. If a hearing is necessary, they're done online as well, and they're done on the Zoom platform. If you're obviously familiar with that, many of us are using that right now. So the hearings take place on Zoom. There's also tenant duty counsel available on hearing dates. So that's a resource that's available for tenants on the day of a hearing. And like I mentioned, we have the online dispute resolution, whether that's done by the parties before the hearing or on the day of the hearing. It's a great service that's available to all of the participants in the board process. And then I've included here some additional resources and some links that I thought some provincially are helpful, and then some locally for the London and Middlesex area. Legal Aid Ontario is a great resource, will help get you set up with legal services for a matter or a dispute that you're dealing with. I don't know if they give advice with respect to entering into a lease, but they could certainly help you with any difficulties that arise afterwards. Neighborhood legal services, I think they could potentially assist with entering into lease negotiations, reviewing the documents. And then Western University Faculty of Law has an excellent legal clinic as well. So all great resources for you to be aware of. And then the Landlord and Tenant Board is a very user-friendly website. So I've brought you to the LTB site right here. You can see that you've got the two. So these are the two things I mentioned before. Tribunals Ontario portal. This is where all applications are filed. But then there's this really handy tool here called Navigate Tribunals Ontario, which helps you figure out what application you might need to file. And then down the side here, you can see all the forms and information that way, and then laws, rules, and decisions. So there's some really helpful information. So I'll take you to legislation and regulation. Of course, we know that's the Residential Tenancies Act. And I think there's some information there about the Human Rights Code as well, because you'll remember it's the only piece of legislation that trumps or is, we'll say, more important than the Residential Tenancies Act. But here, rules, practice, directions, and guidelines. These are really excellent, helpful guidelines for really anything that arises in this area of the law, so residential tenancies. If you have questions about what happens at a case management hearing, or how to ask for an adjournment, if your landlord's filed an application and you need to adjourn it or reschedule it, how do you go about doing that? What are tenants' rights? If your landlord's brought a non-payment of rent application and you need some information about that process, Guideline 7 is great, relief from eviction. If you'll remember that we talked about no fault grounds of termination. So when a tenant enters into a lease, again, they have security of tenure. They can give notice to leave for any reason or no reason, but a landlord can't do that, right? A landlord has to fit either within a fault reason, so the tenant has done something wrong, or the landlord thinks the tenant has done something wrong, and then they would serve a notice for that, or a no fault ground, which is the tenant didn't do anything wrong. It's just that the landlord needs to move into that rental property, or the landlord has to do some work on it and they need vacant possession. So in that case, then the landlord would serve a form. Commonly, it's an N12 form. And this guideline here, guideline 12, can give you a lot of information about that process and the kinds of things that would have to be complied with, just so that you are familiar with your rights and obligations in that instance. There's a guideline specifically on human rights as well, whether it's a tenant defending an application on the basis of a protected ground under the Human Rights Code, or if the tenant has asked for accommodation and hasn't been accommodated, and so the tenant is looking to bring an application about their human rights. So that can be done. So it could be a defense or a claim made at the Landlord and Tenant Board. So all of this information is really helpful. It's a great place to start and just sort of educate yourself with respect to residential tenancies. And then there's even this Renting in Ontario page, which talks about the Residential Tenancies Act before the lease begins, rights and responsibilities. So all very accessible information on the board's website. So certainly get familiar with that. If you have questions, it's a great place to start. I'll try to move this over again here. And I think that brings us to the end. So we'll open it up. I haven't seen if any questions have come in, Haydam, but if you have any questions, please let me know.
Thank you very much for this very informative presentation. I'm pretty sure it is enlightening so many people, so thank you very much. And yes, we do have actually some questions, but I was saving them, until we can have that chat. And again, for everyone who's watching us on social media, Facebook, YouTube, if you have any LinkedIn or Twitter, please feel free to type your question to the chat so I can read it. So actually, starting with the rent increasing, you've mentioned that for the new building units, that there might be increase for the rent. It could be beyond, the 2.5 limit. So the question is, should that increase be reasonable, approved by the board, Landlord and Tenant Board, before it's applied, or it's just become applicable by a notice from the landlord?
Yeah, so if it is an exempt unit, so if it's a new unit, so post 2018, if it's a new unit, then there's no measure of reasonableness or anything like that. It's really just whatever the landlord has identified they want the rent to be. The only limitation is that they have to serve proper notice, so 90 days written notice in advance of the rent increase. But it can be for any amount, and the Landlord and Tenant Board doesn't review those rent increases.
And we are here just to discuss the law, not the justice, which is could be totally different, because I don't know, I'm not, I would be very conservative with having unlimited authority given to someone. So okay, then I can increase my rent for 50% just by my own notice, without having any kind of appeal or review. But it is what it is.
Yes, and I will say that in practice and in the industry, you don't typically see that, because it's what the market will bear, right? Yeah. So.
Okay. So if you signed up for a lease agreement, if you put the deposit and then you've changed your mind for a certain reason, find something better, decide that you don't want this anymore, does the landlord have any right to hold the deposit and not give it back to you? That I mean, with the deposit, the first and last month
Yeah.
rent.
So the landlord may be able to hang on to that. It depends on the circumstances. So if the landlord's able to re-rent the apartment, and so they don't experience any losses, then they can return that. But if they can't re-let the unit for say 2 months, then they can apply that last month's rent to the last month of the tenancy. Which might be the first month, right? You might have the first and last month be the same. You'd get your first month back, but maybe not that last month. But it depends on the circumstances.
Okay, and we do have also an interesting question here. Could the landlord just set a term in the tenancy agreement to prevent the tenant from bringing any pets to the house?
So,
or to the home, to the unit?
Yeah, so some landlords do have policies or rules that they don't want pets in the home. If the rental application could specify that, but a term in a lease that says no pets is not enforceable. It's void. And so the landlord wouldn't be able to terminate the tenancy because the tenant has a pet. There are some exceptions if there's allergies or it's a shared space with the landlord, then there can be some exceptions. But generally speaking, you can't have your tenancy terminated because you got a dog or a cat.
And another interesting question, you've mentioned that the Landlord and Tenant Board might not be the place you want to be ended at. Taking into consideration the huge amount of files that the Landlord and Tenant Board have now, do you think it is reasonable to start a case taking into consideration that it might take you 1 year or maybe more to have a hearing date?
I think everybody sort of has to make their own decision about pursuing litigation, because an application at the board is litigation. It can be stressful for people. I think it's important to look at what the remedy is that you're looking for, and it's always preferable to see if you can reach a resolution as between the parties first. But if you're not getting anywhere, then you can file an application. And while the wait for a hearing is about 8 months right now, we do have this dispute resolution, online dispute resolution that's available to parties who are willing to participate. And you can do that right away. As soon as you file, you don't have to wait for a hearing. You can try to resolve it with a neutral third-party mediator.
So to the gentleman who asked the question, it is 8 months now, not 1 year, which is more reasonable. So last but not least, you've mentioned that if the landlord would like to move into the unit, they can evict the tenant. What if they did evict the tenant and then they did not move in, they re-rented the rent for, of course, a higher amount of rent? Is there any option left in that case for the tenant who were evicted?
There is. So depending on the circumstances, so a landlord, when they give that notice, they have to do so in good faith. And if something happens after, like this question says, is that they didn't move in, or and then they charged more rent, so they continue to rent it, then there would be a presumption of bad faith on the landlord, and there is an application that can be filed by the tenant to get a remedy for having vacated a rental unit in what may have been bad faith by the landlord.
I see. Well, we are always, telling even the students that try as much as you can to avoid the litigation process, because it's, could be long process. It could be costly. It could be, so as much as you can, just try to negotiate and to settle something friendly, especially because, you know, when we are talking about landlord and tenant, we are talking about neighbors, people who are living together, you know, at certain area and space. So I think I do support, you know, what you've just said, that it's much better to try, you know, settle things down and try to avoid litigation as much as we can.
Yes.
Okay, so any other questions? I'm just looking to the platforms if there is anyone saying once. Well, it seems that this is everything we've got today. I am so grateful to Kristin for all of this information and presentation. This video will remain into our website and social media for further reference. So this information, you know, that useful will be continuous for everyone who even did not get the chance to attend this session with us today.
Terrific. Well, thank you very much for having me. It's been a pleasure.
Thank you, and it was an honor to have you. So thank you, everyone, and we are looking forward to see you again at another session with Rights and Responsibilities Awareness Initiative. Stay safe and stay well. Bye-bye.